sworn in, okay, before we begin again. Are both sides ready for the jury to be brought in? Is there anything we need to take up?
Oh, yes, Your Honor. The defense, by agreement of the state, has added to what was pre-marked as Exhibit A, put into evidence as 1, and if the court...
Detective Johns, just pause right there one moment.
If the court recalls, 1 was comprised of 1A through 1I, and we've added 1J this morning, which is the suggestion of death in the family law case that was brought up during Mrs. Bridegan's redirect. Was
there any objection?
No, Your Honor.
Okay. All right, so that'll be admitted into evidence. Detective Johns, I'm going to have the jury brought in, and I wanted you to come in, so the moment that they come in, we get them settled, I'm going to have you walk forward. If you can sit there you can sit there if you want, just for a moment. I'm going to bring the jury in, okay? All right, Mr. Holman.
I don't know if I like this. Did you fold this? Try it. Just feel it's tight.
Can he just clip it on? This one's on too.
I didn't know we were doing that.
All right, welcome in, members of the jury. Thank you. Everyone may be seated.
It's on now.
Members of the jury, we are in the third day of trial, and just to remind you where we are procedurally, Detective Johns completed his direct examination by the state of Florida. I'm going to ask Detective Johns, he's present here in the courtroom, to come forward. Since there has been a night's recess, I'm going to ask that you take the oath again, and if you could make your way to the witness stand after that.
Detective, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. And just watch your step, okay? All right, Mr. Dreiser, you may cross-examine. Do you need to move that for your... Okay. All right, you may proceed.
Thank you, Your Honor. Good morning, Detective. How are you?
Good morning, sir.
Thanks for being here. You all settled in?
Yes, sir.
Okay. Detective, you would agree that this is by far the biggest case of your career?
Yes, sir.
Okay. This case is not only a big case because of the media attention, it was a long and exhaustive investigation, correct?
Yes, sir.
And I want to ask you a few questions about both. From a media perspective, do you agree that this case did in fact get major media attention?
Yes, sir.
Not only during the course of your investigation early on, there were news reports, correct?
Yes, sir.
And there were, when people got arrested, the court was recorded, correct?
That's correct.
So not only from what the media kept reporting as you guys got updates in the case, when people got arrested, whatever happened in court was made publicly available, right?
As far as I know.
Sure. Anyone that wanted to watch it on numerous live streams could know exactly what was happening if they so choose to do that, correct?
I mean, as far as I know, I wasn't present for everything, but as far as I know, it was, yes.
Right. And you also know that as your investigation went on, you would sometimes purposely release information, correct?
There were times during the investigation where a decision was made to use an arrest as a tactic, yes.
And there were some times where tactically you did not release information so that the public could not know, correct?
Not necessarily. I'm not sure what you're referring to.
Okay. You sometimes purposefully release information, like the blue truck, and we'll get to that later in my cross-examination. But there were also pieces of information that only law enforcement knew about the investigation that was not publicly available, especially early on in the case, correct?
That's correct.
Okay. Maybe I just didn't ask you a good question. We both agree to that fact, right?
Yes.
Okay. And as part of the exhaustive nature of this investigation, it was 11 months before any arrest was made for this particular case, right?
Yes.
So there's a lot for me to ask you about today. You agree with that, right?
Yes.
Okay. And you were the lead detective in this case?
Yes.
Detective Lamont helped you?
He was my co-lead.
Okay. And as you guys got developments, you never let up, right? You just kept pushing and trying to get more and more evidence to make your case, correct?
I would kind of reject that premise. You follow up on leads, and you either develop new leads and you follow those leads, or information kind of dies out and that lead dies out.
But over the course of 11 months, you were looking for leads. You were looking for new information.
Yes.
I mean, that's what that whole table up there is shell casings from the night of, tires that you later collected, boots that you later collected. I mean, that was what you were doing, right?
That's correct.
Okay. Now, and you've answered most of these questions, but personally, you are only part-time at the sheriff's office or the Jacks Beach Sheriff's Office now?
Yes.
Okay. You're only putting in about 10 hours a week?
Depends on what's going on. It can vary.
And you are now a financial planner in your own private business, unrelated to law enforcement?
That's correct.
Okay. And because of what you described as some of the background that you have working at banks, they sort of deem you the finance guy at Jacks Beach Sheriff's Office?
I handled most of the financial investigations. That's correct.
Okay. But you agree you don't have any degrees in banking?
I don't think there is a degree in banking per se, but no, I do not have a degree in finance.
Or a business degree of any kind?
No.
Okay. You don't have any degrees in taxation?
I hold a license in taxation, but I don't have a degree now.
You're not a CPA?
I'm not a CPA.
Okay. And in terms of being a financial planner, there are certified financial planners or CFPs. You're not one of those?
I'm not a CFP. I am an enrolled agent, which is a designation that the Treasury issues.
Okay. But nonetheless, without ever having worked a homicide before, because you were on call, this became your case. Is that right?
That's correct.
Okay. I want to get some background, some context, because I think some names have been thrown out in this case. Do you remember saying the name Jeremy Ordway yesterday?
Yes, sir.
Jeremy Ordway became the tenant of Potomac
around the beginning of the year.
Well, it was after January, moving into February, right? And I'll show you the lease later, but I'm trying to give them some context of who Jeremy Ordway is. That was the new tenant of Potomac between January and February of 2022, right?
That's correct.
Okay. And then, of course, we've all heard the name Henry Tenon, and I think you said on your direct examination that Henry Tenon was still living at Potomac after the homicide. Detective Burrell yesterday told us he didn't think he was living there. I'll let the jury make the decision. But my question to you is, Henry Tenon and Jeremy Ordway have a relationship, correct?
Yes, sir.
Okay, it's not like, you know, in a typical situation, you move into a new place, the old tenant can't stay there unless, in fact, you would agree that they are friends.
I would say they're friends.
Right. And it's because Jeremy and Henry Tennant's father, before he passed, they had a relationship, correct?
Yes, sir.
Okay. So in some ways, they were family friends.
It's fair.
They lived on the same street at Potomac.
Correct.
Right. So when Henry Tennant is seen over at Potomac, and I'm going to show you, and we're going to talk a whole lot about it this morning and afternoon, about why those two people are together, it's because they, in fact, are friends. And it's not unusual that Henry Tennant would be at Potomac, correct?
That's correct.
Okay. I'm going to try to go chronologically, but yesterday the jury was left after seeing an interview of Mario Fernandez, and I'm sure you remember that, correct?
Yes, sir.
All right. And I want to ask you a lot of questions about what they heard and what they didn't hear in that interview. Is that fair?
Okay.
When someone goes in for an interview, let's start with a few basic premises. He came in voluntarily,
Yes, sir.
with no hesitation.
That's correct.
He didn't bring a lawyer with him.
No.
He answered your questions.
Yes, sir.
And during that interview of Mr. Fernandez, as a detective, you're gauging whether he's telling the truth or he's lying, correct?
At that point, I'm making a record of what he's saying. I'm not necessarily gauging whether he's telling the truth or not.
In that moment, you're making a record, but certainly as a good detective, you're going to try to find out, was he telling me the truth or was he telling me lies? You have to have done that, right?
Part of what is done when you're doing an interview is you are making a record of what people say, so that later on, if something is said that contradicts that, you have a record of what they said earlier.
That would be a lie.
That's true. Yes.
So in a nutshell, I asked you a simple question, which was, you're trying to make a decision after you listen to what they say, you do some detective work, and then you say, was this guy being truthful with me, or was this guy being a liar? That's part of your job, right?
Sometimes, yes.
Yeah. And you're also trying to, and you would agree, people react differently in police interviews, right? There's no right way to react, right?
Correct.
So Mr. Fernandez talked a lot. You would agree with that?
Yes.
Some people could say, well, he talked a lot, so he was nervous. Some people could say, if a person comes in and they don't really expand on their answers, that could be suspicious, right?
Not in itself, no.
Right, because everybody reacts differently to police interviews.
Correct.
So just the way a person acts doesn't tell you one thing or another about their involvement in a crime, correct?
No.
Okay. No, meaning yes, you agree.
I agree with you.
Thank you. Okay, so now let's talk about questions that the state didn't ask you yesterday. Mr. Fernandez told you that there was an issue with AB, sorry, Judge, about purple hair. Do you recall that?
Yes, sir.
And how Mr. Bridegan, Jared Bridegan, went bananas. I don't think that was the word he used, but he went apoplectic. He was pissed off about her wanting to dye her hair purple, correct?
According to what Mr. Fernandez said, yes.
That's exactly right. According to what Mr. Fernandez says, we don't know. But as part of your detective work in this case, you went and spoke to Bishop Curry, correct?
Yes, we did.
And he confirmed that Jared did confront him about purple hair, correct?
I don't remember if it was necessarily about the hair color or something else, but yes, he did go and speak with Bishop Curry.
Yeah, and it was about Bishop Curry giving advice to the Gardner family, and he's a bishop.
Your Honor, the state's going to object. This is all hearsay.
Grounds? Okay. Response?
I'll ask it differently.
All right.
You were able to confirm that what Mr. Fernandez told you about the confrontation between Jared Bridegan and Bishop Curry did in fact happen.
I was able to confirm that there was a confrontation between the two of them.
Thank you. And in fact, that Bishop Curry was pretty taken aback by how aggressive Mr. Bridegan was during that confrontation.
I don't remember his specific language that he used. I believe he was surprised by interaction.
The aggressive nature of the interaction.
I don't remember him saying aggressive or using that type of language. I just remember him being surprised by it.
He wasn't pleased with Mr. Bridegan coming to his house, was he?
No.
Thank you. You heard Mr. Fernandez tell you that the child reported that during that date night, on the night of the homicide, that Mr. Bridegan took a phone call, correct?
Yes.
Mr. Fernandez wasn't there during that date night, right?
That's correct.
There's no way he could have known that, to tell you that, unless someone told him that, correct?
That's correct.
And you were able to confirm that during that date night, on that day, Mr. Bridegan did in fact take a phone call. It lasted about 20 minutes at the beginning of the date night.
Yes.
So again, what Mr. Fernandez told you checked out to add up to something that actually did happen, right?
Yes.
Okay. There was some school issues brought up by Mr. Fernandez. And Mr. Fernandez told you that the way the school perceived Miss Bridegan and Mr. Bridegan and whether they were friendly, you were able to talk to some of the school teachers in this case, correct?
We talked to one school teacher, yes.
Okay. And I'll represent you. They're going to testify in this trial. But they confirmed that the Bridigans weren't really happy with the school situation, correct?
I don't remember the specifics of the interview. I don't remember them talking about that particular aspect of it.
Okay. Would you agree with me that whatever they tell the jury about how the Bridigans perceived their happiness with the school situation would be the truth?
Your Honor, I'm going to object to speculation.
I'm not asking him to speculate what they're going to say. I'm asking him to speculate, accept that whatever they tell the jury is how they felt.
The court will sustain the objection on other grounds, invading the province.
Okay. So Mr. Fernandez reported to you that Kirsten Bridegan was unhappy with the notification that the school gave out to the public regarding the death of Mr. Bridegan. Do you recall that?
Yes.
You were able to confirm through Mrs. Bridegan that she did in fact contact the school and she was not happy with that.
I don't remember if I confirmed that through her, but it was confirmed.
It was confirmed. So that was also true,
Yes.
correct? Lastly, do you recall one more fact that was confirmed? He told you that Mr. Bridegan's brother had left the church, and there was strife in the Bridegan family about that, right?
I don't know what the particulars were in the strife of the family. I do know that he did, in fact, leave the church.
Right. So let's break that down to what I'm asking you. I'm not asking you about the particulars of the strife. So let me ask a better question. Mr. Fernandez told you in response to issues that were going on that Mr. Bridegan's brother left the church.
Yes, that was a statement that was made by Mr. Fernandez.
And then later you were able to confirm that that was true.
Yes.
So again, as part of the work that you did post the interview, you were able to confirm, for example, he told you the children's therapist was Mercedes McGowan, correct?
Yes.
And that was a big issue that he talked about. You were able to confirm the children's therapist was in fact Mercedes McGowan, correct?
Yes, sir.
And there was issues about whether the Bridigans wanted her going to Mercedes McGowan or whether the Gardner camp wanted her to go to Mercedes McGowan. You confirmed that was a true issue, correct?
Yes, sir.
Okay. So what you're learning from him all sort of panned out, correct?
Everything we've spoken about so far, yes.
And then when someone's giving a police interview, they could just come in, if they wanted to make it seem like they were distancing themselves from a crime. They could say something like, well, there was really no problems between us and the Bridigans, you know, little issue here, a little issue there, but we got along great. And then you would confirm that's not true. Mr. Fernandez didn't do that, did he?
No.
I mean, he told you there were issues. He told you what the issues were, and everything he told you checked out in terms of those issues that he identified, correct?
He was very candid about the issues between them.
Okay. And then, do you recall answering a question yesterday about motive? It's a big issue in this case. The government's alleging that the motive in this case is a child custody issue. You agree with that?
Yes.
Okay, and they asked you, before we even played the interview, at what point in the investigation did you come up with this motive? And you said, well, Mr. Fernandez said that he wanted to do a social investigation so they could get majority time sharing. Do you recall saying that?
Yes.
And that's the snippet of information that you gave the jury before that interview, correct?
Yes, sir.
Okay. But the jury's now heard the entire interview, correct?
Yes, sir.
And it's in evidence, right?
As far as I know.
Okay. But and I don't want to put words in your mouth. I want to use the exact words of what was spoken. So let's see what we can agree on. And at any time, if you need to look at the transcript, you let me know, or we can play the video. Okay? Mr. Fernandez told you that there was an issue with the children, AB and LB specifically, and Mercedes McGowan, the therapist, right?
Yes.
And the issue was they thought it was really good for the children, meaning the Gardners, Mario Fernandez and Shanna Gardner, and the Bridigans did not want the children to go to therapy. In a nutshell, that's what he was telling you, correct?
That was the statement made by Mr. Fernandez, yes.
Right. And then, in response, you say, the therapy, okay? Take my word for you?
Okay.
And then Mr. Fernandez says he wanted it to stop. And he was saying that he never agreed to it and that they had to go and tell the kids, I don't know if he thought that they were in there with the kids. And he goes on to talk about why Mr. Bridegan wanted the therapy to stop. Fair enough?
Yes.
And then you say that's why he wanted it to stop. And then Mr. Fernandez says he wanted it to stop. Then he sent us a thing through his lawyer. We forwarded it to our lawyer. And our lawyer was more or less, is this real? Is this serious? Our lawyer legitimately told us that he ignored it because he didn't think it was serious. And he waited out the time. Then he went back in and got serious and was like, I haven't received a response and blah, 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 blah. We asked our lawyers, hey, can you respond to this? Because this is getting out of hand now, and it's absolutely ridiculous. Fair enough?
Okay.
Then Mr. Fernandez went on to say, our lawyer was prepared to be like, I hope this goes forward so I could just crush him in court. We were hoping that he was going to push it so that we could file a social investigation against him. I'm going to stop there for a second. Mr. Fernandez was saying, we hope that he was going to push it. Push it was the fact that Mr. Bridegan, he was Mr. Bridegan, you agree with that, correct?
Yes.
That Mr. Bridegan was going to push the issue of taking the children out of therapy. That's what Mr. Fernandez is telling you.
I can only say that, yes, that's what the transcript says, yes.
That's all I'm asking you.
Okay.
What he told you. That's what you're basing your response to this jury yesterday was, we believe the motive, in short, was he wanted to push a social investigation and majority time sharing. You got that from that interview, correct?
That is part of a larger context of things.
Sure.
Yes.
But right now, in the interview, this is the part where we're talking about those two things. Social investigation, correct?
Yes.
And we're about to get to the majority time sharing.
Okay.
So to back it up, he's now telling you what the lawyer was going to do if Mr. Bridegan pushed the issue of taking the kids out of therapy, correct? That's where I left off?
I mean, you're reading a small bit of a long interview.
I'm going to read the whole.
I understand, yes, what you're saying based upon that part of it, yes, that's accurate.
Okay. So then Mr. Fernandez goes on to say, because up to pretty much this point, the primary goal, because it wasn't amicable and because how they're being with the kids, we were more or less fighting for the kids to have a chance and for Shanna to have majority decision making. Okay, I'm going to stop there. That's different than majority time sharing. That's just decision making for health decisions, correct?
I believe that he wanted them to have control over the children. That's how I perceived his statement.
That's how you perceived it. But the words
Your
are,
Honor, I'm objecting to this line of questioning because it's calling for
Let me
speculation.
see your side button.
Madam Court Reporter?
May proceed.
Thank you. I want to make sure we know exactly where we left off, because I want every word to be considered in this paragraph, because this is the part where you learned about the majority time sharing, correct?
Okay.
So I left off exactly with decision making. So the first thing that Mr. Fernandez said after you were discussing the therapy was that it would be better if maybe she got decision making. That's the word that Mr. Fernandez used, correct?
Right.
Okay. And then in the next sentence, Mr. Fernandez says, if she could have more timeshare on her end, if it was 60-40 or whatever, we could bend it just enough, it'd be great because the kids would be better off. If we could push them into the corner of all the interaction with the kids, we need all to be together so they could just suck it. I don't care if they're suffering because they are uncomfortable, okay? And he was obviously not referring to the children being uncomfortable. He was referring to the Bridigans, correct?
Correct.
And this whole concept that you told the jury yesterday for motive was that Miss Gardner, you believed, and Mr. Fernandez wanted majority time sharing is what you said, correct?
That's what the transcript says.
Right. But 60-40, meaning 10% more time sharing, Detective Johns, correct? That's what Mr. Fernandez said, correct?
In the transcript, yes.
Right. So in the transcript, he's saying if we could just bend it slightly, it would be better off for the children, correct?
That's what the transcript says.
And 60-40 is 2 days a month, correct?
Okay.
Nowhere in that transcript does Mr. Fernandez ever say that they were trying to take away Mr. Bridegan's time sharing, correct?
I think if you look at the total context of the interview,
Yeah.
I believe he was saying that they wanted them to have majority control over the children.
By way of 10% more. I mean, a majority is 51%. I mean, you know from your business background, that's what a majority means, correct?
Yes.
So he says 60-40, 10% more is the majority.
Yes.
We're not speculating because you keep saying, well, that's what Mr. Fernandez said. That's exactly what Mr. Fernandez said. If we could just have 60-40, we could bend it just a little bit, the kids would be better off. That's what he said.
That's what the transcript says.
You keep saying that's what the transcript said. Detective Johns, he is the transcript. You are the transcript, Detective Lamont is the transcript, and Mr. Fernandez is the transcript. That's what the transcript is. It's 3 people that were talking in a room, correct?
Yes.
So when I say that's what Mr. Fernandez said, that's what he said, and then it was transcribed, correct?
That's correct.
Okay. And to be very clear for the record, when I keep saying that's what was transcribed, it's from what Mr. Fernandez said in the interview, not the transcript, because they saw the interview in its entirety yesterday, right?
Correct.
Okay. Now, during your investigation, you never took the time to read the family law docket in this case?
It was read by one of my colleagues.
Okay, but you personally as the lead detective never read it?
I have since read it.
Since the last time I asked you, and you told me you hadn't read it, you've now gone back and read it?
I have read the docket, yes.
Okay. Did you actually read the pleadings?
No.
Okay, well, I'm going to represent to you that many of them are in evidence, okay? So I'm going to walk you through that. Is that all right?
Okay.
So let's start with let me go to my notes. Defense Exhibit 1A. When you say that since the time I asked you last, which was only a few months ago, right?
Yes.
So it had been far after Mr. Fernandez was arrested until the time that you read the docket.
That's correct.
Okay. This is the docket that we're talking about, and this is, for the record, Defense Exhibit 1A. Do you agree with me this is the docket?
Looks to be the same.
Okay. And the docket, as you understand it, means all of the pleadings, all of the motions, all the filings are contained within the St. Johns County Family Law Clerk of Court, right?
Yes.
So everything that was done, the jury now has an opportunity to look through because it's in evidence. Do you agree with that?
As far as I know.
Okay. You're also aware that there was a family group chat that existed between Shanna Gardner, Jared Bridegan, Mario Fernandez, and Kirsten Bridegan.
Yes.
And there were thousands of messages in that family group chat.
There was a lot, and I don't remember the exact number.
And you and your team had an opportunity to look at all of those, correct?
Yes.
And there's nothing that you're aware of in there that had any evidentiary value as to a threat of violence?
That's correct.
Any kind of, let's just not beat around the bush. It was about scheduling for the most part, correct?
But things you would probably expect to find in a family chat.
Yeah. Medical decisions between the children?
Yes.
Pickups and drop-offs?
Yes.
Exchanging medical supplies or school supplies?
Yes.
Okay. And that comprised over years of information that you and your team were able to investigate. And you would agree sometimes there were little snips from one side or the other, right?
Correct.
Okay. But in all of that, there was nothing, as you've already told me today, that you can say, yeah, this went to motive, this went to violence, this went to why we believe Mr. Fernandez is involved in the crime out of the thousands of messages that you read, correct?
That's correct.
Okay. Now I'm going to go back in history and I'm going to show you Defense Exhibit 1B. This is the consent final judgment of dissolution of marriage. Okay? This is, in fact, the initial document that Jared Bridegan and Shanna Gardner agreed to regarding time sharing, or as the state uses, custody in this case. You agree with that?
Yes.
And you know, even with just limited family law knowledge, that a consent final judgment means both parties agreed.
Yes.
They didn't go to court and a judge said, after all this fighting, I give you X, I give you Y. These two parents, for their two children, came to an agreement, and the agreement says, on page 4, page 4. Section 7. No, go down to the pairing plan, sorry. So part of the consent final judgment is also their property, is what they do with their cars, what they do with their houses, correct?
Right.
Okay. And as part of the property, are you aware that Ms. Gardner was ordered to give Jared Bridegan $390,000?
I think it was part of their marital residence, but I don't know the specifics of their divorce.
Right. She got to keep the house. In exchange, she gave him $390,000 in cash.
Right.
Okay. Just want to make sure you're aware of that. Now, where it says time sharing schedule, in section 7, you can go down. It'd just be easier if I have the. Okay. See where it says in section B below, this schedule is intended to be a 50-50 time-sharing schedule.
Yes.
Clear as day, they agreed to 50-50 back in 2015 by agreement of the parties.
Yes.
Okay. Now I want to show you what's been put into evidence as Defense Exhibit 1C. This is called a supplemental petition to modify time sharing and support and other issues. Can you see that?
Yes.
So this is now Ms. Gardner going back to the court and saying, I'd like to change what we agreed to, right?
Correct?
Okay. And now, in the supplemental petition that was filed by Ms. Gardner, if you would go to page 3, paragraph 3. This is the right one. May I approach the hard copies? It's just
Yes.
hard on the computer. This day, there are two. It's the other one. The one that she copies on. May I approach the witness?
Yes.
Oh, actually, I'm going to...
Is that still the same exhibit?
It is 1C, and I'm going to try not to be so archaic. I'm going to use some technology.
All right.
It takes a second. All right, we got it. All right. Detective, can you see the supplemental petition to modify the parenting responsibilities?
Yes.
Okay, my question was to you. This is Ms. Gardner going in and asking for a change, right?
Correct?
Read for the jury what Ms. Gardner, without the assistance of a lawyer, asked for the judge to do in modifying timeshare.
A more beneficial time sharing schedule for the children has been successfully utilized since June 2016 of 1 week on and 1 week off with a Wednesday date night.
Okay? So she's just asking for a different 50-50 time-sharing schedule, correct?
She's asking for a modification to the time sharing agreement.
You have to agree with me that week on, week off is a 50-50 time-sharing agreement.
Just reading what the document says.
I'm asking you. If you're with your children for 1 week, and then they're with the other side for another week, and then you're with them for 1 week, and you go a whole year or a whole lifetime, wouldn't you agree with me that's an equal time-sharing schedule?
Yes.
Thank you. And in this particular case, and the jury has the ability to look at all this evidence because it's been admitted, it's been marked, and it's in, they can determine what the change was. So without going back, the last one, it was a few days in between, and now she was saying, let's just go a week on and a week off. And you would also agree that she's telling the court that they've already started doing it, and it's been successful since 2016. That's what she says, correct?
Based on the document, yes.
Okay. Wasn't trying to take away any time sharing from Mr. Bridegan.
Not according to this document, no.
Okay. Now, let's go to paragraph 5 of the same document, because now we've asked you about what she asked for. Now let's ask why she asked for it. Can you read paragraph 5 to the jury?
Schedule change has been agreed upon mutually because it allows them to have more stability for the majority of the time, as well as looking forward to a midweek visit with the opposite parent. Having the kids rotate homes every few days was too emotionally upsetting because it was too much instability for them to handle.
Okay. Sounds consistent with what she's asking for, correct?
Yes?
Okay. And did you know, because you've read the docket, that that's exactly what they did? That by agreement, without a judge having to get involved, they agreed to week on, week off with a Wednesday date night. Right?
Okay.
Right?
That's what this says, yes.
Yeah. Well, that's what she asked for, and then they actually came to an agreement to do that. right?
Yes.
Now, in 2019, a few years later, Ms. Gardner files another supplemental petition, which has been marked in evidence as defense 1D. Can you see that?
Yes, sir.
Okay. Take as much time as you need to review it, but would you agree with me, after you've had time, that this supplemental petition doesn't seek to modify time sharing in any way, equal time sharing in any way?
Give me just a moment to read it.
Sure. May I approach the witness?
Yes.
I'll just give you a whole hard copy so you can look at the entire thing.
Thank you.
For the next one.
Okay. What was your question? Sorry.
Would you agree with me that nowhere in that document in 2019 does Ms. Gardner seek to take away any time sharing from Mr. Bridegan?
It just discusses how they'll split up more holidays, and then there's a mention about their schools.
I'm going to ask you all about that.
Okay.
But I thought my question was pretty clear, so let me ask again. Do you agree, after reading that entire document, that nowhere in that document does Ms. Gardner seek to change equal time sharing with Mr. Bridegan?
No.
Thank you. What it does do, so I'll give you a chance to tell the jury whatever you want, is it goes to codify or make Wednesday night the official date night, correct?
Correct.
All right. Now I want to pause on just that point, because in this case, there was a crime that occurred on date night. You agree with me on that?
Yes, sir.
This docket, these pleadings that I'm showing you are all publicly available, correct?
Yes, sir.
So the idea that that's some personal detail that only the Bridigans would know and only the Gardner Fernandez residents would know is simply not true. It's public information, correct?
The docket is publicly available to my knowledge. Sure. I don't know if there are certain restrictions on documents when they involve minor children or not. I don't know I can't say who would and would not know.
I'm not asking.
Well-
We don't know who went on the docket and read it. I'm just saying it's publicly available, correct?
Yes.
When I asked you about it at your deposition, you said you hadn't read it. You came in today and said you did read it, correct?
That's correct.
You didn't need to get a login or a password or an account, correct?
I couldn't open the actual exhibits. I could only see the docket because I didn't have a registered account.
Okay, but as a public user, you are able to go through and look at it and do it. You just didn't, correct?
I honestly don't answer the question.
You don't know how to answer the question. You don't know the answer, right?
I don't know.
Okay. So Wednesday she asked for Wednesday night to be the official date night. That's what it does ask in that petition, correct?
Correct.
All right. Then it goes on and it has an issue with school, correct?
Correct.
And then Ms. Gardner acknowledges that the communication between Ms. Gardner and the Bridegan camp, it can be frustrating at times, right?
That's correct.
So she says, we'd like for the court to implement OFW. Do you know what OFW is?
The app, the Wizard app?
That's right, Our Family Wizard. And that's an app that parents can use to better and effectively communicate in a family law case, right?
Correct.
And the other interesting part of her asking for OFW is that it also can be court monitored, correct?
As far as my understanding.
Right, so that it keeps people honest. If once it's on OFW, it's recorded, and if the court is so inclined to look, they can. That's one of the tools that OFW offers and why courts utilize it, correct?
As far as my limited understanding, yes.
Sure. And of course, in this case, Ms. Gardner is saying, let's give OFW a try. That's what she's asking for in the supplemental petition.
That's correct.
Right. Then the next issue that Ms. Gardner brings up is now an issue between the new step-parents that are involved. Because in 2019, Mr. Fernandez is now involved with the children, correct?
Yes.
Kirsten Bridegan is now involved with the children, correct?
Yes.
So read for the jury what Mrs. Gardner petitions the court in regards to the parties, new step-parents.
Are you talking about the number 10 on the screen there?
Please read paragraph 10.
The father is currently insisting that the mother's new husband may not exercise overnight time sharing with the minor children when the mother is away. He is additionally creating problems with the mother's new husband being involved on a more general basis with the minor children. However, he insists that his own new wife should be fully involved in the children's lives. The father's new wife is a positive influence in the children's lives, as is the mother's new husband. Both new spouses have strong and positive relationships with the minor children. This paragraph should not be construed as a personal attack on either step-parent.
She went out of her way to make sure that even with what they wrote in that paragraph, that no one would perceive it as a personal attack, right?
That's what it says, yes.
Ms. Gardner went out of her way to say that Ms. Bridegan is a positive influence in the children's lives, correct?
According to this document, yes.
That's all I'm asking you about, what's in the
Yes.
That's all it says, is that she's a positive influence in their lives, correct?
Yes.
And she's saying that Mr. Fernandez is also a positive influence in their life. That's what the document says, correct?
Yes.
Right? And she's asking for the court to clarify their old parenting agreements that don't address step-parents, correct?
That's correct.
She didn't do this outside of court in a self-help mechanism. She went to the judge, she described what the issue was, and she asked for court intervention, correct?
That's correct.
Without personally attacking anybody, right?
According to the document, that's correct.
And without taking away a single second of time sharing from Mr. Bridegan, correct?
According to the document, yes.
Well, you keep saying according to the document. So let me ask you, what document are you going to tell me exists that's contrary to what I'm asking you? The whole docket's in evidence. Show me the court document that says that she took away time sharing from Mr. Bridegan.
I'm not aware of a document that says that.
Because it doesn't exist, right? That's why I'm walking you through this, to show that the documents that do exist show time and time again that they had an equal time sharing schedule that no one interfered with, correct?
Correct.
It's been alleged in this case that this was one of just the most toxic family law cases. So that's why I'm walking you through this. So now I'm going to show you what's been marked and put in defense exhibit later in time as 1E. Can you see that?
Yes.
It's a motion for school determination and request for expedited hearing, meaning school's coming up, we got to figure out what school they're going to, can we get a quick hearing? You agree that's what it says?
Yes.
Okay, now I'm going to show you what's been marked as 1G. I'm sorry, 1F for the record. Consent order regarding school choice. Without going to court, the parties immediately came to an agreement and picked a school. Correct, Detective?
Yes.
By way of agreement, they just said, we can do this on our own. This is what we came up with. That's what the consent order says.
Yes.
Now I'm going to show you what's been marked as Defense Exhibit 1G. This is the mother's motion for declaratory relief. If you want to take a moment to read it, I can give you the hard copy. This is regarding an issue regarding the breathing machine for LB, correct?
That's correct.
Simple issue. They were trying to figure out who should keep the breathing machine, correct?
That's correct.
And the jury's heard somewhat, but LB had a breathing issue and some medical issues where he could only live in certain parts of the country that were near to
Sea level.
Right?
Yes, sir.
Okay. Now I'm going to show you Exhibit 1H. Mr. Bridegan responds to the motion, correct?
Yes, sir.
Okay. Now I'm going to that was 1G for the record. Sorry, Your Honor. And now I'm going to show you what's 1H. Again, no court intervention. The parties came to an agreement and a consent order on that exact issue was entered into evidence, or was filed, correct?
Correct.
All right. On the family. So to wrap it up, it's all in evidence for the jury to see, but when there were issues leading all the way up to the time of the homicide, they went to court and they agreed, correct? By way of consent.
According to these documents, yes.
Are you aware, has anybody reported to you that there was some nasty trial in this case where witnesses were called and mudslinging occurred that I'm just not asking you about?
No, sir.
May I approach?
Yes.
I'm going to collect a document and drop off a document.
Okay. You may throw out, Mr.
Thank you, Your Honor.
Okay.
That sticker is for the clerk's office. Okay, thanks. Did you get a second to look at it?
Yes, sir.
I keep forgetting because I'm a dinosaur, but there's better technology where everybody can look at it together. I'm showing the witness what's been marked as 1J and entered into evidence. Detective, this is a suggestion of death.
Yes, sir.
This was not filed by Ms. Gardner herself. This was filed by her attorney, correct?
Correct.
And you know that because if you go to the second page, it says respectfully submitted Denry Mason, correct?
Yes.
And you know that was her family law lawyer.
Yes.
And it has two paragraphs. One, that Mr. Bridegan died on February 16, 2022. That's true?
Yes.
And don't you think after reviewing the entire docket, and you may not know this, that that's required, that when a party in a family law case dies with minor children, that the court needs to be made aware? Does that shock you?
No.
Okay. And 2, there is not currently any pending issues before the court and no hearings are scheduled. That was true, correct?
Correct.
Because if you look on the docket sheet, and I'll be glad to show it to you, 1A, the last open pending issue was 4 months prior in October of 2021.
Yes.
Correct?
Yes.
And the case was closed.
Yes.
I'm going to switch gears from the family law case, okay? To give the jury a little bit of background, Mr. Fernandez and Ms. Gardner, they lived in Jack's Beach at the Marsh Inlet address, right?
Yes, sir.
Mr. Fernandez owned a few rental properties in town, correct?
Yes, sir.
One of them was the Potomac address.
That's correct.
And at a certain point in time, Mr. Tenen lived at the Potomac address, and then like we talked about, and I'll show you some documents in a minute, Mr. Ordway moved in and became the official tenant of the Potomac address, correct?
Yes, sir.
But January 5th of 2022, the year of the homicide, Mr. Tenen was in fact the tenant of Potomac.
Yes.
In this case, there was some FBI analysis done on cellular devices, correct?
That's correct.
Okay. And in this case, Agent Blythe, who I expect the jury will hear from during the course of this trial, he was not a detective in this case, correct?
No.
He was solely utilized by law enforcement to do cast analysis or cell phone analysis of location of devices, correct?
Yes.
He didn't subpoena any documents?
No.
You and your team took care of that?
Yes.
So whatever documents he used from T-Mobile or Google or whatever the case may be, that's information that your investigative team subpoenaed, gathered, got by way of warrant, however, and then you would provide that to Agent Blythe, correct?
Yes, sir.
If there was this particular address in this case, that's not something Agent Blythe would be aware of. He would rely on the investigators and the detectives such as yourself to give him that information, correct?
Correct.
So if there was a location of interest, not something Agent Blythe would have any idea about, he would rely on you to give him the information, and then he would map it, correct?
Yes, sir.
And I'll allow him and the government to go through all of his analysis, but in fact, he did mapping in this case.
Yes, sir.
And there are certain days of interest that the information you provided him, he mapped for you at your request, correct?
Yes.
All right. So let's start with January 5th, okay? On January 5th, yes, and this for the record is, I'm just going to go back. I'm sorry, Detective. Before we go into January 5th, I forgot a question that I need to ask you, okay? Can I just take you back to the interview of Mr. Fernandez?
Yes, sir.
All right. And I'm sorry to jump around. I made this mistake. Don't hold it against me, please. Do you recall in the interview that Mr. Fernandez kept saying, I don't know why he got out of the car?
Yes, sir.
And let's talk about those interviews again. It is not uncommon that in law enforcement, a person can give a detail during an interview where they shouldn't know that detail, correct? Let me ask a better question. Sometimes there are details about a crime scene that only people that were at the crime scene are aware of. Do you agree with that?
Yes.
Okay. And sometimes when people give interviews, they oust themselves by accident, revealing a detail that only somebody at the crime scene or law enforcement would know, correct?
That's correct.
Okay. And when Mr. Fernandez was interviewed, it was a couple weeks after the homicide?
Yes.
An important detail that this jury should know is that you had not released to the media that the tire was in the road. That was not public information.
I do know it was released eventually. I don't remember the exact timeline that it was released.
Okay. I'm not concerned about when it was released.
Okay.
What I'm concerned about is that at the time Mr. Fernandez was interviewed, you know that it had not been released at that point.
Correct.
That's what I'm asking you. So when he's saying, I don't know why he would get out of the car, he doesn't know that there was a tire in the road, correct?
I don't know I can't testify to what he knows or doesn't know.
He doesn't say anything about a tire, correct?
Not during the interview, no.
Right. He says something about maybe he knew the person in front of him, or maybe I just can't imagine why he didn't run him over. He gives all sorts of, hypotheticals as to what happened, but he never mentions that there's a blockade or a tire or anything obstructing the roadway. Never even suggests that at all, correct?
That's correct.
Okay. And I'm so sorry. I meant to ask you that question, and I forgot. May I have a moment, Your Honor?
Yes. Mr. Dreiser, can we take a break shortly?
It was public knowledge that Mr. Bridegan was killed outside of his vehicle, correct? That had been released.
I don't dispute that. I just don't know exactly what was and wasn't released.
To ask it real simple, there's not a single fact that Mr. Fernandez said to you regarding his hypotheticals of what could have happened that gave you any concern that he had more information than he should about the crime that occurred.
At the time of the interview, no.
Right. Good time for a break, Your Honor.
Okay. I didn't want to interrupt you, but so members of the jury, we're going to pause at this time frame. We're going to take 15 minutes, so that would be about 10 minutes after 11, okay? Enjoy your mid-morning recess. Leave your notepads on your chair. Welcome in, everyone. Everyone may be seated. If you could get Detective Johns again.
Go ahead and publish that map. Make it as big as possible. Okay.
All right, Detective Johns, just make yourself comfortable again, okay? Mr. Dreiser, you may proceed.
Thank you.
Thank you.
All right. So, Detective Johns, we're back at the January 5th date, but just to recap, you assisted providing information to the FBI so that they could map slides, correct?
Yes, sir.
Some of the things that you would give were phone numbers, like Mr. Fernandez's, correct?
Correct.
To the FBI. So let's look at the top of, and can you see what's been marked and entered into evidence as State's Exhibit 182?
Yes.
And 182 is a composite of all of the work that the FBI, Agent Blythe, did in this work?
That's correct.
In this case, excuse me, right?
I think it's a slide as part of his overall deck, yes.
Yes. There's a deck of slides. That's the work that Agent Blythe completed in this case.
Correct.
I'm now showing you one of those slides.
Yes.
They're all in evidence, right?
Yes.
Okay. And at the top right corner, it says page 8. So that's an easy way to identify what slide we're looking at, right?
Yes, sir.
Okay. And then at the top, it says 904-566-2633. That was Mario Fernandez's phone number at the time, correct?
Yes.
And then this is January 5th of 2022, so the month preceding the homicide. And it's between 10:56 and 11:51. That's what the slide is suggesting the data shows on page 8 of State's Exhibit 182. Is that fair?
Yes.
And that's information, once again, that you provided the FBI so they could make these for us.
That's correct.
Right? So, in fact, in the legend in the top right corner, it shows, and just, I don't know if the state asked you this, in your homicide training that you said you had, and you said admittedly it was mostly after the homicide, but you do have some CAS training.
I took like an introductory CAS course, yes.
Okay, and these are CAS slides, so you have some familiarity with what we're talking about.
Some, yes.
Okay, and I'm not going to ask you your opinion as to how these slides were made. We all can agree that is what Agent Blythe did in this case, not you.
That's correct.
But in the top right-hand corner, that is, again, where you were involved because you gave the information. And there's a little yellow, I don't know what you call it, marking, and you have the location of interest. See
Yes,
that?
sir. Yes.
And that's the Pablo Hamlet area.
That's correct.
And the jury heard a lot about Pablo Hamlet yesterday. That's the area where the Pablo Hamlet retirement community is and those other apartment complexes where the truck was seen a few times before and after the homicide.
Yes, sir.
Okay? And then you have the Fernandez residence, and that's in the legend in the top right-hand corner, right?
Yes, sir.
And 1511 Marshall is the Fernandez residence, right?
That's correct.
Okay. Fair to say that in this slide, it's just showing that Mario Fernandez was in the area of Jack's Beach at that time.
I'll let Agent Blythe speak to the slides, to interpret the slides.
Okay, so you don't feel comfortable, even with your limited knowledge and this being in evidence, saying, yeah, it's Mario Fernandez's phone number and he's in Jack's Beach. You can't determine that?
I'm not saying I can't determine it. I'm saying Agent Blythe is an expert in this. He created these slides. I'll let him speak to them.
Well, I'm asking you to speak to it. So can you tell us, as the lead detective in this case, who furnished all of the information to make these slides, that Mario Fernandez, according to this slide, is in the area of his home between 10:56 and 11:51?
Yes, it would seem that he is utilizing, during the phone calls that are made on the slide, he's utilizing the green dotted cell towers.
And those cell towers are in the area of his home.
Yes.
You don't know where he is in Jack's Beach, you just know he's home.
I can only tell you what
Sorry,
the slide
you just
says.
know he's in the area of his home.
I can tell you that his cellular device is utilizing the towers that are indicated on the slide.
Okay. You could go to the next slide. On the other hand, you also provided the FBI so they could make maps. Henry Tenon's information, correct?
That's correct.
And then they were able to use geolocation to determine where Henry Tenon's devices went during the course of your investigation, correct?
Yes, sir.
And January 5th is one of the days in which you anticipate that Agent Blythe is going to testify about because you provided him information on those days, correct?
Yes, sir.
So without going into what the evidence shows specifically, you agree that on January 5th, not early in the afternoon in the first slide I showed you, later in the afternoon, Mr. Tenon's devices appear to travel from the Potomac address to Jack's Beach.
Yes, sir.
That you're comfortable saying.
Yes.
Okay. On this particular slide, page 9, you've added the crime scene, right?
Yes, sir.
You have no information that Henry Tenon's device went to the crime scene on January 5th, correct?
Based upon the slide and the data points that are here, it doesn't show that.
Okay, can you go to the next slide, please? I'm sorry, the next page number. This is a more zoomed in location of where the Fernandez residence, the location of interest is, correct?
Yes, sir.
All of this is Henry Tenon's device, correct?
That's correct.
Looking at page 9 or 10, you have no information as to where Mario Fernandez is on January 5th.
Not on the slide, no.
Okay. And I'll give you an opportunity to look at all of the slides from January 5th. But in all of the information that you provided the FBI on January 5th, you have no information as to where Mario Fernandez is on that date, correct?
There are no data points available, correct?
There are no data points available, therefore, you don't know where Mario Fernandez was on January 5th, correct?
There is no physical evidence to say where he was at.
That's, okay. Do you agree that's the same thing as saying you don't know where he was at?
Correct.
Could be at his house.
Correct.
Could be anywhere else. You have no idea.
Correct.
All right. So now, on January 5th, Henry Tenon's device does travel into the area of the Fernandez residence and the Pablo Hamlet residence, correct?
It travels to the data points that are here, which is, looks like down 15th onto Marsh Inlet and then down to the Cradle Creek area and then a little bit down Fairway.
Okay. Because of what you said about your comfortability, I'll save my cross-examination for Agent Blythe as to where exactly it went. But in this slide, no information about Mario Fernandez.
That's correct.
Okay. And I'm sorry, I'm going to stop saying slide. Page 10, can you go to page 11? This is more time period.
Yes.
Mr. Tenon's devices, correct?
That's correct.
No idea where Mr. Fernandez is or his devices are.
There's no information on the slide now.
So you did not provide that to the FBI, and you don't know.
Correct.
Next page. More zoomed in. Evidence that Mr. Tenon's devices were in the area of Jack's Beach on January 5th, right?
That's correct.
No information as to where Mr. Fernandez is that day.
No.
There's not a single piece of information that you can provide this jury on January 5th that you know that Mario Fernandez was with Mr. Tenon.
There's no physical evidence available for that now.
There is no evidence of that.
Correct.
And on January 5th, Henry Tenon was still the tenant of Mr. Fernandez, correct?
Yes.
So if the argument were to be made that he has no reason to be in that area, his landlord lives in that area, correct?
That's correct.
It's the 5th of the month, correct?
Correct?
It's the last month that Mr. Tenon was a tenant of Mr. Fernandez, correct?
I believe there's some information. I don't remember he was the end of December when he stopped being his tenant, or was it the beginning of January?
So you don't know as you're the lead. I mean, I'm asking you. Jeremy Ordway became the tenant of Potomac come February 1st, correct?
Yes.
Okay. So it's the last month that Henry Tenon was at the home prior to Jeremy Ordway, correct?
That's correct. I mean, I don't know exactly when Mr. Tenon's lease ended, is what I'm saying.
Understood. You did learn during this investigation that Mr. Tenon was having a hard time keeping up with his rent, correct?
Yes.
Okay. And that Mr. Fernandez was trying to work with him the best that he could, correct?
I believe there was some conversations that he was trying to work with him, yes.
And he was trying to get whatever money he could until he just could no longer keep him there because he just couldn't keep up with his rent payments, correct?
I assumed that that was the case, but I mean, I don't know exactly when the lease ended, is all I'm saying.
I gave you that. We don't know exactly when it ended. We just know when the new one started. But at this point in time, it's January 5th, and a person who, at that time or just prior to, who you just told the jury was having a hard time keeping up with his rent, is briefly in the area of his landlord's house for about 30 seconds on January 5th, correct?
That's correct.
And that's all the information that you have.
Based on this, yes.
I'm going to show you what's been marked and put into evidence as Defense Exhibit 19. Can you make that bigger? Okay, scroll down a little bit. All right. I'll zoom in. You and I may be more familiar than the jury with the evidence. You've seen this before?
Yes.
Okay. And this is a rental agreement between Jerry Ordway and Jeremy Ordway for the Potomac address, correct?
Yes.
And this is the and it's signed, if you scroll to the bottom. It's signed by Mr. Fernandez, correct?
That's correct.
And it's signed by Jerry Ordway and Jeremy Ordway?
Correct.
And it's 1/27/22, right before the 1st of February.
Yes, sir.
And you were able to find that lease at Potomac when you guys did the search at Potomac?
Yes, sir, that's correct.
And you were able to confirm with Jeremy Ordway that he lived there and he was the tenant?
That's correct.
Okay, so that all adds up.
Yes.
And through your investigation, you learned that Jeremy Ordway did, in fact, pay rent to Mr. Fernandez.
Yes.
You saw checks where Jeremy Ordway wrote his rent payment to Mr. Fernandez.
Yes.
You confirmed that people that would live at Potomac would also do some work to improve the property, and sometimes that would subsidize their rent, correct?
That's a vague question. I don't understand.
Okay. Mr. Ordway was confirmed that he did some work at Potomac while he was living there.
Yes.
Okay. You learned that Mr. Tenon did work at Potomac while he was living there.
It was stated that he did some work, yes.
Okay. No dispute that Jeremy Ordway took over and continued to pay Mr. Fernandez for living at 5239 Potomac Avenue.
No.
We talked a little bit about Mr. Tenon and his financial situation around the time of the homicide. I think you said he was having trouble keeping up with the rent.
I think you said that, but
And you agreed.
yes,
And he was not in a good financial situation at that time of his life, correct?
that's correct.
And you know that because you've seen his bank accounts, and they don't have a ton of money in them, right?
That's correct.
And you know that because you have pawn records that you found where at that time Mr. Tenen was pawning things, correct?
I don't think I ever saw pawn records.
Okay, let me show you. What's been marked as Defense Exhibit 21, an Advance America pawn receipt from 2/26/2022. Oh, I'm sorry. I said the wrong thing. Pawn receipts. Advance America is he went on 2/26/2022 in Defense Exhibit 21, and he got a
Cash advance.
cash advance.
Yes, sir.
Okay. So approximately 15 days or so after the homicide, Mr. Tenen went and got a cash advance.
That's correct.
And as a detective, that would tell you that he needed money, correct?
That's correct.
Let's talk a little bit about John Biggerstaff, okay?
Okay.
John Biggerstaff is a longtime friend of Mr. Fernandez, correct?
That's correct.
John Biggerstaff's daughter went to high school with Mr. Fernandez, correct?
Yes.
And that's how he met John Biggerstaff decades ago, correct?
As I assume, or what I've heard, yes.
No reason to dispute that fact, right?
No.
Okay. And over the years, Mr. Fernandez and Mr. Biggerstaff did work together, correct?
Yes.
Mr. Biggerstaff had a little side business called 904 Handyman,
Yes.
and Mr. Fernandez had rental properties, correct?
Yes.
And there's no dispute, because I'm going to show you what's been marked into evidence here in a little bit, that you know that John Biggerstaff went to Potomac and did work. He did tile work there, correct?
Yes.
And you know that because you saw messages between them about doing tile work, and then we'll get into poll camera footage. You actually saw him show up and do the tile work.
Right.
All right. So no dispute that John Biggerstaff did work for Mario Fernandez.
No.
You also know that Mario Fernandez would hang out with John Biggerstaff from time to time, correct?
Yes.
They certainly weren't best friends, but they'd have a beer together every once in a while, right?
That's correct.
You also know in this case that John Biggerstaff's son, Juan Biggerstaff, around the time of the homicide, was getting married here in town, correct?
Yes.
And you know that Mr. Fernandez helped set up tables and chairs by using his pickup truck and delivered it to the wedding venue, correct?
That's correct.
You were able to confirm that with receipts from the table and rental company, right?
Yes, sir.
You were able to confirm that with some cellular data that Mr. Fernandez went after the homicide to a storage unit, and you were able to confirm that by people who saw him drop off tables and chairs.
That's correct.
Okay. So no dispute that they knew each other and they did things for one another like delivering tables and chairs, right?
Correct.
Like tile work, correct?
Correct.
On January 25th, you have reason to believe with cell phone data, and I'll save it all for Agent Blythe, that Mr. Fernandez went over to Mr. Biggerstaff's house on that date, correct?
That's correct.
You know, because we just talked about all the things, that that's not unusual that Mr. Fernandez would go to Mr. Biggerstaff's house, correct?
I mean, I have a limited period of time that we reviewed, but it didn't seem unusual.
Right, didn't seem unusual. And while he was there, you have no idea what he was doing at John Biggerstaff's house, correct?
That's correct.
You don't know if they were having beers. You don't know if they were involved. And let's just get it out in the open. Mr. Biggerstaff was a swinger, correct?
Yes, sir.
And his wife was a swinger, correct?
I never spoke to his wife about it.
Sure enough, okay. But Mr. Biggerstaff wanted to film people having sex with his wife, correct? They were into that.
I don't know.
You don't know?
I know on one occasion he did film his wife having sex, but I don't know. I can't say what he was into specifically
Are you sure it was only one occasion, Detective?
that I'm aware of.
Would you like to see, not the video, I don't think that's necessarily important, that on other dates, there are other men, not Mr. Fernandez, who had sexual relationships with Mr. Biggerstaff's wife. You dispute that?
No,
Okay. And you don't dispute that Mr. Biggerstaff participated in that, correct?
no,
It wasn't that Ms. Biggerstaff was cheating on Mr. Biggerstaff. That was a lifestyle that they chose to live, correct?
according to Mr. Biggerstaff, that's correct.
And the videos that we'll spare the jury from watching that we found in this case and we saw with our own eyes, correct?
That's correct.
Because you got Mr. Biggerstaff's cell phone downloads, and when you got them, you saw the videos, right?
I did not personally go through every single video, but there were a lot of explicit videos on his phone.
You're not disputing what I'm saying to you, are you?
I'm not.
Okay, so just so we're clear, I'm not making this up. This is what was on the phone, right?
That's correct.
And on that particular day, the day I've been asking you about, January 25th, you've already told me you don't know what Mr. Fernandez was doing over at that house, correct?
That's correct.
Other times, you had seen a video where Mr. Fernandez did have sex with John Biggerstaff's wife, correct?
That's correct.
But on that day, there is no video, but you just don't know, right?
Correct.
Ears in the garage, sex with his wife, helping him build a tool bench in his garage, or the tens of thousands of other things they could be doing together. You just don't know, correct?
I don't know.
But what you certainly have no evidence of is that Mr. Biggerstaff gave Mr. Fernandez a 10-millimeter firearm, do you?
There is no physical evidence of that now.
Okay. When you say no physical evidence, there is no evidence of that, correct?
There is no physical evidence of that.
Okay. So let's talk about John Biggerstaff and this 10-millimeter. Yesterday, I thought I heard you say that it was a very rare weapon. Is that what I heard you say?
Yes, sir.
You also told me in one time that we've previously spoke that it was no golden goose.
That's correct.
Okay. You also said yesterday it's no unicorn.
That's correct.
There are tens of thousands of 10-millimeter firearms out in the universe, correct?
It's probably accurate. I don't know exactly how many have been manufactured.
And let's talk about John Biggerstaff's first, and then let's talk about what your investigation revealed as to other 10-millimeters, all right? Back in 2016, John Biggerstaff bought a 10-millimeter firearm, correct?
That's correct.
All right. So just a little time perspective here. The homicide's in 2022.
Correct.
We're going all the way back to 2016, right?
Right.
I'm going to show you what's been marked in evidence as State's Exhibit 191. Can you publish? All right. Can you see that?
Yes, sir.
And this is a firearms tracing document that the ATF did in the assistance of this case, correct?
Yes, sir.
And this is how we know that John Biggerstaff owned a 10-millimeter back in 2016, because he bought one, right?
Yes, sir.
He bought it legally, right?
Yes, sir.
There's paperwork on it, right?
Yes.
And we know that he had a Glock 40 Gen 4. That's the manufacturer and the model. That's in the top right-hand corner, correct?
That's correct.
And we also know that the serial number of that firearm is BBG L770, correct?
Yes, sir.
So that's the basis of how we all know that 6 years prior to the homicide, John Biggerstaff owned a 10-millimeter, right?
Yes, sir.
So then you know that John Biggerstaff got himself in trouble right around the same time that he bought that gun, correct?
Correct.
He got arrested federally after the purchase of that gun in 2016, correct?
Yes.
And as a part of his arrest, a federal magistrate ordered Mr. Biggerstaff to forfeit and remove from his possession all of his firearms, correct?
Yes.
I'm going to show you what's been marked as Defense Exhibit 5. Okay. Can you see Defense Exhibit 5 on the screen, Detective Johns?
Yes, sir.
This is, in fact, an order setting conditions of release.
That's correct.
You go all the way to the bottom. While I'm scrolling down, you can see refrain from possessing a firearm, destructive device, or other dangerous weapons. Defendant shall immediately remove all firearms he currently owns from the residence, correct?
Correct.
And this was signed by a federal magistrate here in the Middle District in a building about a block from where we are right now, Monty Richardson, correct?
Correct.
You agree with me that federal magistrates take their orders pretty seriously, correct?
Yes.
And they ordered him, as I just read to you, to get rid of all of his firearms, correct?
That's correct.
So in order for him to do that, you would agree they just don't take your word for it. They make you fill out a firearms affidavit where you mark all of your firearms, their serial numbers, their information, so that you show and prove that you no longer have them in your possession, correct?
That's correct.
All right. So now I'm going to show you what's been marked, and that was signed, for the record, October 28th of 2016.
Correct.
And he hadn't been convicted of a felony at this point. This is just when he got arrested. This was his conditions of release order.
Correct.
Just make sure that's clear. Okay. This document's a little harder to see. Blow it up. You know, States Exhibit 190 is, in fact, the federal firearms affidavit that John Biggerstaff filled out in 2016, correct?
I believe this list was completed by his son, but yes.
Right, because of course he can't be in possession of firearms once Magistrate Richardson says you can't be around your firearms. So by the very nature of filling out a firearms affidavit, you have to have some help, right?
Yes.
Because if you sat there and did it yourself, you'd immediately be in violation of the order, right?
That's correct.
And you came to learn that law enforcement was present when they did this, someone from federal probation.
I believe so. I don't know that for sure, but
Of course, you weren't there, but that's what you learned, is that his son, Juan Biggerstaff, was there with someone from federal probation.
that's what was told to us, yes.
Okay. And he had he had 20 firearms, right?
Yes.
So let's just be clear what this shows and what it doesn't show. We know he bought a 10-millimeter firearm in 2016, previous to this federal firearms affidavit being filled out. Do you agree with that?
Yes.
So if we are trying to look to see if we had a unaccounted for weapon, this would be a good spot to find out, right? Let me ask a better question. We got to look to see if a known firearm that we know he owned is included on this federal firearms affidavit. That's an important detail, correct?
Yes.
Okay, so let's zoom in to line 7. Do you see line 7?
Yes, I do.
And you've seen this document before. This isn't
Yes.
the first time. It says Glock, right?
Correct.
It says 40 Gen 4, correct?
Correct.
So just let's go back in time, just one exhibit before. It was a Glock, right?
That's correct.
It was a 40 Gen 4, correct?
That's right.
And then I read to you the serial number, and I read to you BBGL 773, I believe.
That's correct.
0, excuse me. The exact same firearm that Mr. Biggerstaff purchased in 2016 is documented as forfeited on his firearms affidavit, correct?
That's correct.
Later, in 2017, John Biggerstaff was in fact convicted of a felony, correct?
Yes.
John Biggerstaff, since 2017, has been and is a convicted felon, correct?
Correct.
A convicted felon under federal law cannot own or possess a firearm, correct?
That's correct.
Cannot own or possess ammunition, correct?
That's correct.
Under Florida state law, a convicted felon cannot own a firearm, correct?
That's correct.
They cannot own or possess any ammunition, correct?
Correct.
Okay. If you do, felonies, correct?
That's correct.
All right. You have no information that since 2016 that John Biggerstaff has ever been in possession of a firearm, correct?
I don't know that that's necessarily true. There's some information that he might have taken back his weapons.
Do you have any pictures of John Biggerstaff with his firearms?
No.
Do you have any surveillance of John Biggerstaff with any of his firearms?
No, I do not.
Has John Biggerstaff ever been arrested for felon in possession of a firearm since he has been a convicted felon?
No, sir.
In federal court?
No.
In state court?
No.
The firearm in this case, and the jury will hear all about, and they're going to hear from John Biggerstaff, and they're going to hear the trajectory of that firearm. But I'm asking you, during the course of your investigation, you didn't find a 10 millimeter firearm.
No, sir, we did not.
You interviewed John Biggerstaff to find out if he could tell you where that 10 millimeter firearm is, correct?
That's correct.
And to this day, there is no murder weapon in this case.
It has never been recovered.
So all these shell casings and all these projectiles and all the things that are sitting right here in front of the jury have never been matched to a particular firearm.
That's correct.
And to be very clear, they have not been matched to a Glock Gen 4 with the serial number BBGL770.
That's correct.
There has not been one single person to report to you that John Biggerstaff has had his firearms since 2017.
No, no one has directly said that.
And you've interviewed as many people as you could to try to get someone to tell you that, correct?
Yes?
There's no social media posts where John Biggerstaff is seen with a firearm, correct?
That's correct.
Now let's talk more generally about these 10 millimeter, not unicorns, not golden goose weapons, okay? You did try in an investigative effort to see what you could find in Jacksonville regarding 10 millimeter weapons, correct?
Yes, sir.
And about a month after the homicide, for whatever reason, you chose to go, or you and your investigative team, to Beach's Pawn. You know what I'm talking about?
Yes, sir.
That's just one pawn shop out of, I don't know, probably 100 or more pawn shops in town.
Yes, sir.
Okay. Just one that you picked?
We just, it's happened to be the only licensed firearms dealer in our jurisdiction. Due to the nature of pawn shops, we have a relationship with the owner. So we went to the pawn shop in Jack's Beach that we knew that we could go to the owner and ask for his assistance.
And he assisted you?
Yes, he did.
Okay. I'm going to show you what's been marked and put into evidence as Defense Exhibit 55. I don't think it matters. Just show one for the moment. when you went to the pawn shop, you were able to get some paperwork regarding 10mm firearms that were sold by Beach's Pawn, correct?
That's correct.
And at the only pawn shop that you went to, in your jurisdiction, 6 10mm firearms had been sold when you went on March 15th of 2022. That's the evidence that you were provided, correct?
Yes, sir.
Okay. And out of the 6 transactions that are in evidence, every single one of them, and do you see the blacked out portions, Detective Johns?
Yes, sir.
I'm going to represent to you that we redacted their names. And do you agree that's just where someone who purchased a 10mm did so at Beach's Pawn?
Yes, sir.
And do you agree just to protect their privacy, that's why we did that?
That's correct.
There's no other information on that sheet that gives you any more information other than, in this particular case, a Glock 40 10mm firearm, correct?
Correct.
And I'll show all of them to you if you need to, but would you agree with me that out of the 6 that were sold from Beach's Pawn, 3, 50%, were Glock 10mm firearms?
Correct.
The exact model and the exact caliber, thank you, of firearm that you were looking for.
Yes.
Okay? And you didn't interview any of those 6 people, correct?
No, we did not.
You just looked and you saw whether or not they were associated in any way with a blue two-tone truck.
That's correct.
And if they weren't, you just scratched them off your list.
That's correct.
Mr. Fernandez isn't associated with a blue two-tone truck, correct?
No.
Do you have any records from any of the dozens or maybe 100 other licensed firearms dealers in the greater Jacksonville area that I can show this jury of how many other 10mm were sold?
I don't have numbers of that, and we developed no leads from any of the ones that were looked at.
You only looked at 6.
Correct.
No leads because you didn't talk to anybody, right?
Right. No leads were developed from them.
All right, I'm moving on. Now I'm asking you about all the other places. You have no other paperwork for me to show you or for me to enter into evidence to say, yeah, they went to 20 other licensed firearms dealers, they got another 100 Glock 10s, and they did or did not speak to those people. That does not exist in this case.
No.
You didn't go anywhere else and specifically look to associate anybody connected with Henry Tenon or anybody else regarding a 10mm in this case.
No.
You do know that Henry Tenon on 2/9 of 2022, this is just days before the homicide, he did pawn some stuff, right?
Right.
Again, proof that Henry Tenon didn't have any money.
That's correct.
He's pawning he's pawning items that he owns. He's getting cash advances, correct?
Correct.
But a clue could be that in Defense Exhibit 20, this is a value pawn receipt. Can you see that?
Yes, sir.
You agree with me it's a value pawn receipt?
Yes.
You agree with me that the date is 2/9/2022?
That's correct.
You agree that it's Henry Tenon in the left-hand corner?
Yes, sir.
Right? 8701 Old King Road, correct?
That's correct.
That's not the Potomac address.
No, it's not.
Did you ever go to Value Pawn and Jewelry, the very pawn store that you knew that Henry Tenon dealt with, to see if they had sold any 10mm firearms?
No, it did not.
May we approach without the court reporter, Your Honor?
Yes. All right, members of the jury, I've asked the lawyers, and both sides are doing a good job. I'm asking them on longer witnesses to kind of do what I would normally do, which is kind of pause at a natural point in their examinations. So I've been told by both sides that this would be a good pausing point. It happens to be right at noon, so we will take our lunch break now. So you're going to go into the jury room while we set up your lunch. Remember to follow the communication rules while you have your devices, and enjoy your lunch. We'll come back at 1 o'clock, okay?